Good afternoon, everyone. My name is Bruce Lynn. I'm one of the managing partners of the Financial Executives Consulting Group. We're going to start the main body of our presentation, International Employment Operational Considerations, in just a few minutes. I want to make sure everyone can log on before we start. For those of you who have logged on, you are in mute-only mode, which means that you can hear me, but I can't hear you. If you have questions during the formal part of the presentation, please write them into the question box on the lower right-hand side of your screen, and we'll get to them afterwards. I'll be reading the questions out loud, so if there are questions that are somewhat proprietary, or if you require lengthy answers, we can certainly take them offline. You can talk to myself or Joe or Andrew, who are obviously the experts in whatever area that you wish to talk about. So with that, I'm going to go away, and we're going to start here in about 2 minutes. Good afternoon, everyone. For those of you who have just joined, my name is Bruce Lynn. I'm one of the managing partners of the Financial Executives Consulting Group. We're going to start the main body of our presentation, International Employment and Operational Considerations. But first, a few administrative announcements. You are in mute-only mode, which means that you can hear me, but I cannot hear you. If you have questions, please type them into the question box on the lower right-hand side of your screen, and we'll get to them after the formal part of the presentation. If you have questions that you don't want me to read out loud or those that are somewhat complex, you can certainly email me or Joe or Andrew after the presentation, and we can take them offline. You will get copies of the presentation later on this week or on Monday, and it is being recorded, so if you do have to leave early, you won't miss some of the Q&A that follows the presentation. So with that, I'm going to turn this over to Joe Cesaro. And Joe, why don't you start the presentation?
Thank you, Bruce. I appreciate it. Hi, everybody, and thank you for joining. My name is Joe Cesaro, and I'm representing Global Upside. Today, we're going to talk a little bit about international employment and some of the operational considerations that we have to deal with and think about in the new way of doing business around the COVID pandemic now and as we approach the new year. With me today is my colleague, Andrew Wilson. Andrew is an English chartered accountant by profession, and over the years has worked in several countries with PwC. He also spent time at Oracle, establishing their first 25 international subsidiaries. And in addition to that, he has spent over 10 years, like many of you, as a CFO for a wide range of different organizations. And during that time, has built 4 international networks. At Global Upside, he has led engagements in electronics, manufacturing, and software that involve the big 4 accounting firms in several international law firms. And again, my name is Joe Cesaro, a global business advisor here at Global Upside. I started my career in both domestic and international payroll and business outsourcing services at ADP, and have since then worked with a number of our clients and prospects in support of their international operations as they look to continue to expand. And I think it's important before we talk a little bit more about some of the international contingencies and considerations in the body of our presentation, I'd like to start by introducing our firm, because for many of you on the call, you might not have heard of us or might not know too much about us outside of some of the basic research you might have done on your own. And so at Global Upside, we provide comprehensive incorporation, PEO and EOR, accounting, HR, payroll compliance, and M&A services to support your business expansion, both domestically and overseas. Our integrated business expansion services are delivered via a single point of contact and simplify your day-to-day operations so you can free up time and resources to focus on growth. And so we've been doing this since 1999, where our founders built this business really at their kitchen table, husband and wife, and have grown it to what it is today, where we operate in about 150 countries globally and have reached to a wide network internationally. And so these logos here that you'll see, these are our 4 core brands that fall under the Global Upside Corporation umbrella. The first is our Global Upside brand, and under that brand, you can think of it as really everything from the infancy stages of an expansion, from setting up and incorporating and registering an entity locally, to then having to continue your operations in a compliant perspective and compliant manner in solving your people, payroll, compliance, and accounting complexities. Another arm of our business is called GAVA Talent Solutions. And within this business, we can support with one-off direct and interim hires, or we can support with the entire recruitment process outsourcing. And so what that looks like for your clients and your organizations is if you were looking to attract and retain top talent in international markets, you can rely on us and our recruiters to be an extension of your business to put together job descriptions and go to the market and source interviews and put you in front of the right candidates for your business globally. And then the last 2 arms of our business sort of go hand in hand. The first is Global PEO Services. And we developed this business and this part of our business because we are hearing this request from our clients a lot. We understand that, and especially in this climate, a lot of companies have hesitations with looking to expand internationally, and most importantly, set up an entity. And so through Global PEO Services or an employer of record model, essentially what we can do is leverage our local entity and onboard your employees to alleviate some of that compliance burden and alleviate some of that risk associated with incorporating your own entity. And so that's what's great about Global PEO Services. It's a very flexible model and way of doing business, which doesn't require your clients or your business to set up an entity because we can leverage our own in the local market. And then with that comes our technology called Mihi. And this is our proprietary cloud software for human capital management. This houses things like time and attendance, leave management, benefits reporting. It also has a built-in HR help desk. So if employees or the employer have concerns or questions, they can go into the platform and raise tickets and ask questions accordingly. And so this platform is really the glue that holds an organization together between their domestic headquarters and their international operations. And so I think what you'll notice is that because of our wide breadth of services and our offering is so expansive, it's really what makes us special, and it's a big differentiator between other companies in the marketplace. Because commonly what you'll find, right, is that there are vendors for sort of each one of our arms of business in respect to payroll, accounting and tax, the incorporation process, as well as recruiting. But I think you'd be hard-pressed to find another provider out there that houses all of these services under a single umbrella in a single point of contact. And that's really what Global Upside Corporation represents and can offer. And because of that, we've had some great successes over the years with, I think, some impressive logos that a lot of you might relate to or notice. Companies like Zillow, Energizer. We've got partnerships with IBM and Cisco. And then companies of the likes of Melissa and Doug, which might be a smaller organization. They create children's toys. I know my niece loves them and is playing with their puzzles and whatnot all the time. And so we've really got a wide range of clients in a depth, I think is what makes us very, very special. And with that, I'm going to turn it over to my colleague, Andrew Wilson, who's going to take a deeper dive into really the body of our presentation, and I think some of the talking points that a lot of you are finding interest in and the reason why you registered for our webinar today. Andrew, over to you.
Thank you, Joe, and good morning, everyone. And thank you for having us today. So we're going to talk about specifically, obviously, a lot of the effects of COVID-19 internationally, and it is going to vary by continent, and is really discussing sort of how the environment, the business environment, has been affected by COVID-19 in each of the continents, be it Asia, Europe, or South America, and what really has gone on from a business perspective in the different environments. Just obviously as a preface on this in terms of the different sort of government schemes and government support that is in place in the different countries. Obviously, internationally, there are a lot more extensive social benefits and a lot more extensive healthcare systems that are available for all employees in the different countries. And so in terms of that, Europe obviously has very strong social schemes, unemployment benefits, disability, short-time work benefits, and schemes in place, as well as many of the countries have government healthcare systems that are free to all of the different residents in the different countries, as does South America, and also to a great extent in Asia. A lot of the situations that occurred as a result of COVID-19 did obviously become available to the employees in the different countries as the pandemic took hold, and as as they got into the whole situation of the healthcare supporting them, the sick pay to basically tide them over during the period that they were sick, and also there are extensive schemes in terms of unemployment benefit and paid time off. What is generally prevalent in all of the countries around Europe, South America, and to a lesser extent in Asia is that the governments moved quickly back in March and April to enhance the schemes that were already in place or augment them with new legislation to really come up with schemes that would support them for a period of time during which they hoped they would be able to resolve issues as it related to the pandemic and get through the major periods of time when the population was being affected. So in a lot of the cases, particularly in Europe, they enhanced the sick pay requirements and made it more freely available to come into effect immediately in countries like France and Germany. They also had in Europe short-time work, or what we would term over here more temporary furlough schemes that were in place, where particularly in Germany, where they had put in place after the 2008 recession a short-time work scheme where they effectively paid 60 to 70% of the employee's salary for an extended period of time. And in Germany, it was actually enhanced not only to give them benefits through the end of this year, but also into 2021, and was very defined and very this whole application process, how you went about getting approval, how you received funds, was very much cemented in place so that employers knew exactly what to do when they got into a situation to avoid having to lay off employees, and were able to do the short-time work situation, get reimbursed from the government, and not experience a disruption in terms of the paying the employees their full salaries, or to a certain extent, some of them did at least reduce salaries, but the government kicked in most of the compensation for the individuals and to support the benefits. Similar schemes weren't as well developed in other countries such as France and the UK, Spain, but the governments moved quickly to put in place these schemes so that literally anything from 60 to 90% of the employees' compensation was supported by government schemes that were reimbursed to the employees, and really emphasized continuation of employment and not experiencing mass unemployment to the extent that the companies could stay in business and could support on an ongoing basis. So has had the effect that has supported a lot of the businesses, has continued the employment. Germany has extended their scheme, as I said, well into next year. It is up in the air what's going to happen with other schemes. The UK scheme is due to come to an end in November. The French scheme is still ongoing at the moment, but it's uncertain how long it's going to be funded. So really, I don't think the government's envisaged that it would be really staying in place. And the pandemic would be continuing to affect what's happened for such a long time in terms of the pandemic taking hold. But really, what they've tried to do is really maintain the support of the businesses to prevent sort of them actually having to close unless they were in a situation where they really couldn't afford to remain in place. So a lot of emphasis on continuation of employment in Europe, a lot of emphasis on supporting companies and trying to get through this period of time, and just really recognizing that businesses having to close down and really not have an ability to rehire after the pandemic was going to be very negative to the economies there. Different situation, obviously, in South America. They tend not to have the resources that we have here in the United States or in Europe or in a lot of the countries in Asia. So the emphasis there has been very much to rely on the existing labor laws and statutory requirements that make it very difficult to reduce the salaries and compensation of the workers, and to lay off people without having to consult with tribunals or the labor departments of the different governments. So very much there, they've relied on trying to force the companies to maintain full employment unless they can come up with justification to really, they're in a situation where they're in such dire financial straits that they can't affect any schemes to do workforce reductions, and continuing business really is an emphasis that unless you're having to close your operations down, then there's no justification for you not continuing to employ everyone and keep paying them at the same levels. So different approaches. Obviously, Asia was able to recover very quickly in most countries, Korea, China, Japan to a certain extent. So right now, Asia has fully recovered in a lot of the countries and is roaring ahead. The one exception to that being India, and India is still experiencing very high levels of the effects of the pandemic, and to a certain extent, they're trying to keep the businesses open. They have provided some relief to the labor force there, but haven't really done as much. So emphasis on retention policies, emphasis on governments preventing or trying to encourage businesses to stay in effect, serious effects on business, global mobility, and the ability to move from country to country. A lot of the borders remain closed for any country that is experiencing ongoing levels of the pandemic, that the other countries do not feel safe, as obviously people here in the US continue to experience. So global mobility has been affected, the ability to obtain work permits, visas, employment passes seriously affected, because governments are now emphasizing that they do not want foreign nationals to come into the country, and would prefer jobs to go to local employees. So much like the States has been considering effects on the different visa requirements and the ability of people to stay in the States and work. That emphasis is in all the countries around the world where they really have been discussing trying to make it more difficult for foreign nationals to live and work in their countries, because they want to emphasize putting their own workforce back to work and trying to solve their own problems in terms of their workforces. Next slide, please, Joe. So in terms of temporary layoffs, short-term work, and what's happening in the various countries, as I said, the concept of furloughs is doesn't exist as much internationally. They do have these short-time work rules where really it is a question of trying to maintain at least some semblance and to be supported at least up to 60 to 90% of the compensation of the workers to keep them employed and keep them in the workplace and keep the businesses operating. A lot of this is subject to government schemes in Europe, where there has to be justification of why you're having to reduce the workload economically and from a business perspective. And certainly you go through the application process. You have to provide the justification, and then the government will confirm or deny whether you're granted it. So much the same as the PPG program here in the States, you go through a process. It is very much for the government to decide whether you're being justified in terms of putting your workers on short-term work, and whether they will provide this funding. Or if they refuse, obviously, then you have different decisions to make. But you still have to deal with the fact that the labor laws and the statutory requirements are still very strong in terms of forcing you to continue employment, as well as you have the effects of having other types of instruments in place in the countries, such as collective bargaining agreements, unions, the works councils, which have to be dealt with before you can even consider temporary layoffs or permanent workforce reductions. So a lot of emphasis again in terms of applying and getting government approval. If you don't have that option, then what do you do from a perspective of you still got to deal with sort of the requirements in the country? As I say, sick pay provisions were modified. A lot of countries allowed them to come into place immediately, whereas they used to be waiting periods. So they've allowed people to go on sick pay and have the governments provide support as long as they have sort of the medical documentation in place. And again, it's all about sort of guaranteeing partial or full pay during the period when they're not working or working part-time. And to that extent, it has varied by country. But as I said, Europe, anything from 60 to 90% of the workers' pay is being paid by the government. In South America, really all of the benefit has gone directly to the workforce. So they have paid enhanced unemployment benefits. They paid and enhanced sick leave. They've also made direct payments in some cases to just to the general population to try and support them during these periods. So different approaches by the different governments, depending on the resources and depending on sort of how business friendly they are in terms of supporting businesses directly, or just more oriented towards social programs and more caring about sort of the general population. Next slide, please, Sharon. So in terms of obviously employment laws and what happens internationally as opposed to here domestically in the U.S., in most countries, there is not this concept of employment at will as we have here in the United States. So in most situations, the employees have an employment contract. It defines their rights in terms of their employment as it relates to compensation, benefits, paid time off, vacation, and also their rights in terms of labor laws and statutory requirements. Having an employment agreement, having sort of defined work rules, and having labor laws that govern their employment, they often get into a situation where, depending on the country's employment law, that they have vested rights, and that concepts of constructive discharge apply, so that there automatically are processes in place in terms of if you do want to contemplate, letting people go for cause or without cause. There are defined processes, there are defined notice periods, there's defined compensation that the employees are allowed to in terms of that process. They have rights. They in a lot of the countries they can take you to the courts or to labor tribunals in terms of their entitlements. So in a lot of those situations, you have to have demonstrable evidence, especially if you are trying to terminate without cause, or even with cause, in terms of the fact of demonstrating that the events that led to them being terminated really justified a case where they could be terminated, and for what types of compensation they can be terminated. So really, you're looking at a situation with or without cause, the economic circumstances of the business or specifics to the employee, very high level, a very high bar in terms of justification of the reasoning behind it, and what you need to take. Actions obviously can be individually, but again, that's very specific to the employee, and you have to provide the evidence of why that is specifically to the employee. Or if you're talking about you need to do a more general workforce reduction, then a lot of justification in terms of the reasoning behind why you need to do a workforce reduction of an extensive number of employees, being able to demonstrate that to the government. So it's not as easy as just claiming that obviously the pandemic has affected your business, therefore you need to take these actions. You actually have to demonstrate economically and with financial support what's happening. And some of the countries actually require you to apply to the courts or apply to the Labor Department to be able to go through with these actions. And claiming financial distress does mean that you will need to provide that justification, provide financial support, and that can be both at the local level as well as the corporate level. So U.S. companies wanting to take some actions can really be impacted by this requirement to go through and provide this type of information. Next slide, Joe. So really, as I said, it is a different world out there internationally. Is that every country is different in terms of the processes. A lot of the countries do have defined processes in terms of the labor laws, the notice period, the redundancy severance payment. So in all cases, companies such as ourselves or employment law counsel in each of the countries can assist you with the process, but there are requirements. Often it's important to consult with with the human resources personnel who have experience in the country, or the employment law counsel, in terms of what are the requirements, what are the notice periods. So if you are going to plan to terminate someone, there is required documentation in a lot of countries. There's required ways of notifying them about the plan to terminate them. They are entitled to specific amounts of time, which usually is around the fact of them to consider what their options are, and also to provide them with sort of a period of time when they can look for other employment. So notice periods that apply in the case. There is often a situation as defined documentation in some cases, depending on the nature of it and the number of employees that are involved. Attorneys can be consulted. You have to go to the courts or the labor tribunal or the labor department to justify that. In all cases, it is recommended that if you can negotiate with the employee and get a mutual settlement, it's much more preferable than trying to take action unilaterally, because it may cost you more in terms of the immediate severance or amounts of benefits that you have to pay, but it may save you a lot more money in the long term as you go through and basically, try to terminate the employee on your own and meet the minimum statutory requirements. So a lot of it, there is a risk involved. You have to weigh the risks as opposed to sort of the compensation. And even in some cases, when you are trying to terminate an employee and basically come into a situation that you're trying to get a mutually beneficial severance with them, even that can be rejected, because they're really looking at the situation of saying that you may have agreed that mutual termination with the employee. However, you're still in a situation where they're entitled to due process by law, and therefore that they should be entitled to more compensation as a result of that. So really a lot of protection as it relates to the labor law statute requirements, processes to be run in each of the countries, and a lot of things to do in terms of documentation and support, and even consultations and having legal counsel or experienced human resources personnel such as we have that may need to meet in person with the employee as you go through this process. Next slide, please. And then again, different world as you go international. Do you have these different types of employment contracts? And some of this has been really adopted by countries to try and give themselves capabilities in terms of allowing companies to employ people without having as much onerous terms and conditions of employment for the employees, so that they have at least some flexibility. Because a lot of these countries, particularly Europe, South America, and to some extent in Asia, the employment agreements, as we said, give them vested rights, really entitle them to strong protection because of the labor laws and statutory requirements. So what a lot of the countries have allowed is to have fixed term contracts so that they actually are fixed for a fixed term. This could be for 1 year, 5 years, 10 years, but at least it gives a time horizon where you have a capability that they expire and you can decide whether you want to rehire the employees. And then they have these temporary employment arrangements where you might think of here where we have temporary workers that are working at some of the tech companies that really don't entitle them to full benefits, or they're employed through different staffing agencies and different companies so that they don't have direct employment with the company and don't experience the same benefits as they are entitled to. So really it's kind of a tiered system where the temporary employees don't have the same commitment to full-time employment and longevity, don't experience the same benefits, or fixed-term employees have a fixed time period that they are entitled to be employed. And once that ends, then literally unless the company offers them another contract, then their employment just ends and they are not have that capability. So this tiered system has resulted, particularly in Europe, in terms of their capabilities to have to furlough or let temporary workers go during this period of time. So it really has allowed them, because they aren't entitled to, they're not full-time employees with permanent employment, has allowed them to let those workers go without the same impact in terms of the labor law and statutory requirements. Obviously, the fixed-term contracts allow the employers to let those contracts expire. And as we say here, the statutory requirements and the redundancy and severance payments does vary for the fixed term contracts as the temporary employment, as opposed to the full-time permanent employees that are on staff. Next slide, please, Sharon. The other aspect to consider is that certainly collective bargaining agreements are very prevalent in Europe and in South America. These do typically pertain to industries or can be negotiated at depending on the type of company, the size of the company, can be at the specific level, but these do define and enhance typically the compensation and benefits of the employee over and above their employment agreement. So this can very much impact you in terms of you having to provide more compensation, additional benefits, additional time off, and that has to be considered in terms of the overall packages that you have. It can vary the severance and termination payments that you have to pay. So again, it can enhance the minimum requirements in each of the countries and what's happening there. Union agreements, more in South America and in Asia than in Europe, but union agreements, unions are still very prevalent, particularly in South America and some of the Asian countries. So these can provide more protections. And then works councils, depends on the number of employees in the country, are very prevalent in Europe. And anything that's going to vary with the employment of individuals or collectively employees that are working for a company, there has to be consultations with the work councils, and it has to get their approval in terms of the process and what's going to happen with the individual employees. So again, a lot more hurdles that usually affects you when you're talking about workforce reductions or or closing down operations, are very prevalent in terms of what's going on. Next slide, please, John. So as it works to workforce reductions and reductions in force internationally, as we discussed earlier, it's very much specific to each country, very much has to be justified in terms of the economic and business reasons. We do a deal with a lot of private equity spin-offs and carve-outs, as well as mergers and acquisitions where they want to resize the workforce afterwards, but it really needs to be well planned in terms of any workforce reductions or reductions in force. Every country is a different process. Every country depends on, if you're talking about 1 or 2 employees, obviously it can be very simple. If you're talking about a large number of employees, be it Europe, South America, or Asia, there are defined processes. Some countries, such as the UK, even require you to hire attorneys on behalf of the employees to assist them in terms of evaluating the offers that you're making for them. So a lot of different requirements. Each country has to be well planned. You have to understand at the outset what's the notice periods, what are the minimum statutory payments that you need to pay. You need to go through and understand and do the due diligence in terms of the employment agreements of the employees, any changes in terms of company policies that may have varied it and give them enhanced severance or termination pay or enhanced notice periods. And then what is the documentation and the consultations required in each country? As I said, particularly in South America, you have to apply to the labor courts, or you have to go to the labor tribunal or to the labor department to get things approved. Even in some of the southern European countries like Spain or Italy, you have to go to the courts to get their approval before you can finally terminate employees. So every country is different. Every country requires a process. Really, everyone needs to be orchestrated in terms of the documentation, even to some extent the in personal meetings where you have to meet with the employees and talk about them. And again, a lot of situations, especially if you're trying to avoid liability, often getting settlement agreements signed by the employees and agreements to to really not come back and sue the company at some future point in time. It's worthwhile offering a little bit more compensation to the employees to agree to the settlement to resign rather than be terminated. So a lot of different ways that you can go about this and really make sure that you're protecting the company if you do have to go through these processes. Next slide, please, Sharon. Really, I think that what we talked about today in terms of the employment of personnel internationally, the considerations, the effect of COVID-19, and the economic impact has really affected companies, and depending on your industry, it really has affected the ability to do business internationally. A lot of countries are considering about how do I now retrench, come back on my international footprints, maybe reallocate my resources, or even deal with the fact that employees are working from home more, are moving back to their home countries. And so it really has led to a situation of companies really considering retrenching from their legal structures internationally. So really this section is about liquidation, extinguishment of your international legal entities, retrenchment, needing to go through the processes of how do I withdraw from a country because now I do not see myself viable in that country anymore. And so as you go through, there are requirements in each of the countries from a commercial and legal liability standpoint in terms of notifying customers, vendors, government agencies, making sure that you negotiate, terminate lease agreements, ongoing support agreements that you have. And there are set requirements in each of the countries as you do move to withdraw in terms of making sure everything's closed off, everything is terminated and closed out appropriately. All of your income tax returns are filed, that you filed financial statements where required to notify them about the process before you can actually go and finally liquidate and extinguish your legal entity and tie off everything in terms of the requirements. So very much a set process, very much everything has to be taken care of to basically make that happen. Next slide, please, Joe. So as I said, really, especially from the government perspective, there are requirements where they want to make sure that that you have no liability to them. So they actually require you to prepare and file your income tax return through the end dates when you plan to liquidate, that all of your VAT, GST, HST, sales tax requirements are filed and paid up, payroll tax obligations are taken care of, statutory benefits are being paid to the employees, everything that you need in terms of settling claims with the government as well as vendors, because vendors can come back and prevent the process of you liquidating and extract more to stop you from leaving the country until you do pay them out. So everything's working towards having that notice of good standing with all government agencies before you can finally apply to liquidate and extract yourself from any legal presence in that country and any ongoing needs that you have there. Next slide, Jim. So really, as I said, that you have to go through this liquidation extinguishment process. It can be voluntary, involuntary. Governments can force you to liquidate and extinguish because you haven't paid your liabilities and haven't met the requirements. So if you do have to leave the country where you have commercial operations, then obviously you're in a situation where you can't support your customers locally anymore. So those considerations, companies can force you out in terms of what's going on. And in all cases, it's expensive to withdraw from a country. It is a process. It can take years. So, any country, there are defined processes, and you do have to get approval from all the government agencies. You'd have to get final approval from either the government or the company law requirements in terms of different countries. So plan on an extensive process, and in some cases an expensive process as you try to extract yourself. And I think that brings us to the end of the presentation.
Okay, thank you, Joe. Thank you, Andrew. Now it comes time for those on the session to submit their questions. So if you will type in your question in the question box on the lower right-hand side of your screen, we will take those various questions. It's about 12 minutes of, so I know people do have some things to do, so we want to be respectful of everybody's time. So again, questions that anyone would have. Okay, here's a question here about what are the different laws in each of the Latin American countries regarding employment do's and don'ts during COVID-19?
Yeah, I can take that, Bruce. So as I discussed in terms of the labor laws and the statutory requirements do very much emphasize the continuation of employment and make it very difficult for you to terminate or even do temporary pay reductions during the COVID-19 crisis. Often they require you to obtain permission from the government to go through any sort of workforce reduction or even terminate anyone individually, and often those have to be submitted to the courts or the government agency or what's involved. So it's very much a defined process. It's very much, if you're trying to terminate someone without cause, providing the justification of why doing that, what is providing specifics about the cause, especially if it's economic. And so they do make it very difficult to go through that. It's not obviously impossible to do, but it is a defined process and you very much need to justify it. It does vary by country because of the courts or the labor tribunals are different in each of the countries. The defined process is different, but a lot of the time it does require the pre-justification information, consultation prior to actually notifying the employee and going through the process.
Okay, here's another question. What impact has COVID-19 had on contracted staff as it relates to collective bargaining agreements?
I think that varies by the country. As I said, the collective bargaining agreements tend to be specific to the country. And contracted staff, to some extent, again, it depends on the nature of the contract and what you're planning to, what are they doing for the company. So if a contractor is paid independently as a consultant, they're not really impacted in terms of if it is classified as a true contractor and they're not doing any sort of full-time work, or it's not a fixed contract with the employee. So there's really no effect from that perspective. If they are on a fixed-term contract and really are compensated in a set way, and there is no entitlement to benefits, and that is not in contradiction to the local labor law requirements, then there's no impact. But it is, if you are saying that you have an ongoing contracted situation, fixed-term contract, and you are looking to terminate it because you're now in a situation where you cannot afford to have those contractors, then I think that it really impacts you from the perspective that you have to know with each of the European countries what's going on. Latin America, the protections are in place with the collective bargaining agreements, and they're pretty much set. So again, you have to consult from the perspective that if you have contracted staff that are through staffing agencies or some other form of company that's providing contracted staff, then the government's obviously going to try and prevent you from letting the contracted staff go. So it's very much going to be dependent on the terms and conditions of the individual collective bargaining agreement and the labor laws in different countries.
Okay, here's a question. Has COVID-19 actually reduced the need for local offices where people now can either work from home or, quite frankly, work in the United States and try to get business done in another part of the country, or another part of the world, I'm sorry?
Yeah, absolutely. I think that a lot of companies are reevaluating, where they actually have to have, a legal presence or a physical presence in the country, how you're going to support the staff as you can go forward. And also even from the perspective of if you find the right personnel with the skill sets and the talents that you really want to support your business, I think it's opened up a lot more possibilities in terms of where they work in the world, what is their support environment, so I think that it's led to a whole reevaluation of companies in terms of how they want their workforce to work moving forward. Do they really need physical offices? How are they going to really recruit talent as they move forward, and them being more open to to really try to get engaged with employing someone in different countries, as long as they can contribute virtually as much as they might have done in terms of a collective workforce working out of the same office location. So definitely a lot more consideration in terms of being more flexible, really an orientation towards talent, and really getting sort of the skill sets and the talent in the various countries that really you need to support your business, rather than sort of trying to orientate it to a specific country anymore. So I think it's leading to a lot of reevaluation in terms of moving forward, in terms of people working in the workforce, but also from the perspective that, evaluating your current workforce, and do you really need to have the type of concentrated presence in the country that you had in the past.
All right, here's a question. In the EU, are there EU significant laws in addition to individual country laws?
So there is, the EU does have directives that cover the labor laws and statutory requirements in each of the countries. The directives are enforceable in terms of the fact that they need to be adopted in ways by each of the EU members in terms of their own specific laws in the countries, but they are directives, and then there's some interpretation about how they are implemented in each of the countries, and there are EU level protections for the labor force in place. So, such as the Acquired Rights Directive, where the employees are deemed to have acquired rights in terms of their terms and conditions of employment with the employer in each of the countries. That does govern, what their entitlements are in terms of maintaining their terms and conditions of employment, as it relates to a spin-off or a carve-out or a merger or acquisition, and how what their entitlements are, both from the perspective of maintaining their terms and conditions of employment. And you'll hear two-pay as a particular type of process where what is considered a transition of employment where the terms and conditions are maintained, or have they triggered involuntary termination by not giving them the comparable or equivalent terms and conditions of employment. And that does dictate what their entitlements are in terms of severance, termination payments, ongoing benefits, etc. So they're very much at EU. There are directives, and then they're implemented in different ways specific to each country.
All right. We're almost reaching that sort of magical 1 hour mark here, so we do have time for a couple of more questions. All right, here's a question. We have business in Canada. What are some considerations that we should make as we re-enter the office?
I think Canada's obviously done a very good job in terms of being able to test, do the contact tracing, and really maintain a level of safety for employees that has been very good. They still don't have they've had very few cases in Canada, very few actual deaths as a result of the pandemic. So each province has adopted different safety rules and requirements as it relates to work environments and how people re-enter offices, and what is the requirements from a safety perspective, and the provision of the distance to work between how people interact, etc. So really, you would have to know at a provincial level whether you were in Ontario or you were in British Columbia. Really, what's happening at that, or what are the requirements at the provincial, as well as sort of the city level in terms of what you need to meet to be able to go back safely to the offices.
Okay. All right. We have time for maybe one more question, and then I would like to obviously say thank you to Joe and Andrew for the presentation. I think that 2021 is going to be a very unusual year, depending on how things go. A lot of market forces out there between the election and Brexit, and the pandemic. I forgot about that. So somehow I think business is going to be affected. Any more questions? Okay. With that, I think we're going to close down the session. Again, my thanks to Joe and to Andrew. And as usual, if you're like me, you come up with questions as soon as the webinar is over. If you do, you obviously have Joe's email address or Andrew's email address. So please reach out to them directly, especially if it's questions that might be, proprietary. So with that, I am going to end the session. Thank you very much, and we will talk next time.
Thank you.
Thank you, everyone.
All right, bye-bye.